Okay, well, welcome everybody to the next series in our QX Financial video series. So I just want to welcome Phil Shekerlian to our video and joining us, and he's going to be sharing some valuable insights with us today. Today we're going to be highlighting the merits of marriage or lack thereof.
Thanks for having me again. And I have to be careful what I say because I'm engaged and going to be getting married in Lake Tahoe in a couple of months. So
Okay,
I need to be
we'll
careful what
keep
I
it.
say in case my fiance sees this. But
That's true. Yeah, and
I'll
I've
give
been
you my
married.
unbiased legal opinion on the benefits and disadvantages to marriage.
That's true. Yeah, I'm sure she's listening intently.
Yep.
So we'll keep it as politically and well, let's keep it all very tactful.
Yep. Absolutely. So, the first thing I want to start with is the definition of marriage. So, in the eyes of the law, a marriage is only recognized as a valid marriage in any state in the United States. So, if you were married in a foreign country and your state doesn't recognize foreign country marriages, then that's not a legal marriage in the United States either, for tax purposes, asset protection purposes, community property purposes, none of that. So, you really need to make sure that your marriage is legal in any state in the United States in order to get the benefits of marriage. Um, One of the common myths that people think is, well, I've been with my significant other for 7 years. We live together. We have kids together. Therefore, we are married under common law marriage. So that's actually a myth in most states. Only 8 states actually still even recognize common law marriage, and they're kind of strict about it. It just depends. But those states are Colorado, Iowa, Kansas, Missouri, New Hampshire, South Carolina, Texas, and Utah. Here in my state of California, it's actually been outlawed since 1895. A lot of people think that it was recognized up until 10, 20 years ago. I've heard all different kinds of stories on this, but it hasn't been legal here since 1895.
Yeah.
So the moral of the story is, if you don't have a marriage recognized in a state as legal, then you don't get the benefits of marriage. So let's talk about some of the benefits and disadvantages. Let's start off with the obvious: tax filing. So when you're filing your 1040 income tax return to the federal government at the end of the year, if you are married, well, if you're single, you can file as single and or head of household. That's about it. But if you're married, you have some options. You can file married filing jointly or married filing separately, and there's advantages and disadvantages to each of those. Um, so for married filing jointly, that's typically what most filers will do that are married. It offers the most benefits. One way, and the biggest way, is to even out the tax bracket. It's not as common anymore, but back traditionally, the husband went to work, the wife stayed at home and raised the kids, or maybe the wife did work but didn't make as much as the husband. And although that's not always the case nowadays, things have equaled out quite a bit. They're still not quite equal, and
Mhm.
so you'll typically have a situation where one spouse does make quite a bit more than the other, and that could absolutely be the female as well, that makes quite a bit more than the husband. I actually have some friends that the husband is the stay-at-home dad and the wife is the income earner.
Mhm.
Um, and in that case, you can equal out the tax liability. So, for instance, let's say spouse one makes 225,000 a year, and spouse two only makes 25,000 a year. If they were not married and they were filing separately, then spouse one would have to pay $53,545 in federal taxes alone, and spouse two would only pay $1,815 in federal taxes, and that would be a total of $55,630. However, if they file together, if they're married and file married filing jointly, because they're equaling out the tax brackets, they are both considered in a lower tax bracket now, and jointly they would pay $48,159 for federal taxes alone, which is
Mhm.
about a savings of $7,500 in their pocket. So that's a
Wow.
big difference,
Mhm.
and that's just federal income taxes. When you take state income taxes, the number can get quite a bit higher, especially here in my home state of California. Um, So married filing separately, and there's a lot of deductions that are available to married filing jointly that aren't to others. I'll go over those as I talk about the other filing statuses. So married filing separately, it's usually a bad idea for most people, but sometimes it is necessary or it is helpful even. It may be necessary in the case of a divorce, not a divorce, but a legal separation pending divorce,
Hmm.
or a case where the spouses are estranged for whatever reason and they can't get access to the other one's records. You're forced to do married filing separately at that point. Um, However, sometimes um, it may be beneficial. There may be one spouse may be trying to qualify for like Medi-Cal or Medicaid, as it's known in other states. And in that case, you want to make sure that the spouse applying has the low income. And so if they're not making much of an income and the other spouse is, and they file separately, that can help with their Medi-Cal qualifications. Um, Maybe one spouse has a disproportionate amount of medical expenses to deduct. There
Hmm.
is a floor and a ceiling on that. And if you combine your joint incomes, it may be tough to meet that floor. Um, and if you do it separately, then you may be able to much easier hit that floor, therefore deducting more of your medical expenses. Um, another another situation might be is if one spouse worked for an employer that had a sponsored benefits plan, such as offering 401ks, Roths, things along those lines,
Hmm.
and the other spouse didn't. They were self-employed, or they worked for an employer that didn't offer any of that, or they were just not employed at all. Um, then the spouse that doesn't work for the employer that has the sponsored plan might be limited on their contributions. Therefore, if they do married filing separately, then there's no limitation on those contributions.
Yeah.
Um,
I was going to
One of
say, yeah, I do have a friend who is in that situation, right? Where her husband is an overseas, he's an international consultant, right? And he's the self-employed spouse. And, every year they go through the same ordeal where they basically filed jointly, but he was always late with all his paperwork and all his expenses. And so the moment you mentioned that, I thought of them.
Yeah, that's a problem that I may be facing as well, because I am self-employed. I have my own business,
Mm-hmm.
and my fiance works for a Fortune 500 company, and so that may be something that I'm going to have to look at for myself here in a couple months when we get married.
Yeah. So yeah, you'd have to look at it from both, yeah, scenarios.
Absolutely.
Yeah.
So, married filing separately also has a lot of drawbacks. There's a lot of deductions that you cannot take when you're doing married filing separately. One of the most common ones is student loan deductions. You cannot deduct your student loan interest if you file married filing separately. Um, and there's many other ones, and for whatever reason, I'm blanking on the other ones. I know there's several credits out there, tax credits that can't be claimed by married filing separately. But there are a whole bunch of disadvantages to that. So, talk with your CPA, your tax attorney, your whoever does your taxes and tax planning, to see what is the best way for you to file. Another reason for being married, a benefit, this one is access to medical records. There's something called the HIPAA. It stands for Health Insurance Portability and Accountability Act. It was passed in 1996, and it basically protected. It was passed to protect medical records. Well, it's made things quite difficult for family members to get access to medical records. And essentially, it's anybody knows it's hard enough when you go to a new doctor or hospital to try to get your medical records from a previous doctor or hospital. That's hard enough in itself. But if you're trying to do that for somebody else, say you're taking care of your parent who has dementia or Alzheimer's and you're trying to
Mhm.
get records, it can be almost impossible to get access to that because of the HIPAA law. Not only is it hard enough to get access to your own records, but it's even harder to get access to someone else's.
Mhm.
In addition to that, you could call the same hospital or the same doctor's office, and you could talk to five different people and get five different answers as to what the laws are or what their rules are and what information you can get access to. So it's just a minefield out there of what may or may not happen. There One of the benefits to being married is that you should automatically under the law have access to your spouse's medical records. This includes any legal marriage, including same-sex marriage.
Mm-hmm.
Um, if you're the parent of a minor, you or the legal guardian of a minor, then you should have automatically have access to their records as well. Um, Other than that, it's almost impossible for you to get records unless the person whose records are being discussed is either there in person and is verifying that they give consent, or they have written something out prior to them being incapacitated or whatever the case may be, that was signed and is in the proper legal form.
Mm-hmm.
So, for instance, that would be a HIPAA release, sometimes part of an advanced healthcare directive. If you have that for a family member, then you can get access. But if you don't, you're not getting access to their medical records.
And
Uh,
Phil, who do we go to if we want to fill out HIPAA
yeah, so
documentation?
that's something I can absolutely help out with. That's part of every estate plan that I do.
Excellent.
Um, but any competent, estate asset protection and tax attorney
Mm-hmm.
should be able to help you with that, because, like everything else, you can't just plan for one little thing. You've got to keep in mind the asset protection ramifications, the tax ramifications, everything.
Right. This brings to mind, do you remember that case, the Terry Schiavo case?
Absolutely, yes.
Oh, okay.
Yeah,
Wow.
yeah. That's an important case. If you don't have your healthcare directive in place, that it could lead to a lot of problems.
Wow.
Yep.
Yeah.
And that was a married couple, so just because you're married doesn't even eliminate that problem.
Yeah. That's pretty this is an eye-opening conversation, that's for sure.
Absolutely. Um, Now, so we've talked about some of the benefits of marriage. Well, let's talk about what happens upon a divorce. So, divorce is, for anybody that's been through it, and according to the statistics, about 60% of the viewers out there have. Um, Divorce is hard enough emotionally to deal with, let alone thinking about all the legal ramifications. You after you get past the emotional part and you start dealing with the legal part, you're usually focused on, well, how do I divide up my assets? How do I get to see my kids? How much money do I have to pay to my ex-spouse? Things along those lines. And you're not thinking about, well, what if something happened to me during this divorce process? The divorce process isn't quick. In California, they have a waiting period of 6 months. So you can't get divorced in less than 6 months in California. Typically, it takes a year to 2 years actually to get that process done, and sometimes it can take even a decade to get through a pretty nasty divorce. So you're not thinking about that amount of time that's going to pass, and what would happen if you became incapacitated. You got a car accident or something, or even you died during that process. Well, it's probably surprising to know what actually happens. So first off, just because you filed for a divorce, that does absolutely nothing. And I'm talking about here in the state of California. Every state is a little bit different, but most community property states will be very similar. Um, just filing divorce does nothing automatically to any estate plan or anything that has to do with disability or death. Then, once your divorce is actually finalized, it actually does very little automatically to plan for those situations either. For instance, if the things that do happen automatically is if your ex-spouse had a right to any property in your will or your trust, then the state would treat that as if the spouse if you died
Mm-hmm.
after the divorce, the spouse or the state would treat that as if the spouse predeceased you. Therefore, they don't inherit anything, and that inheritance goes on to the next successor beneficiary that you designated in either your will or trust. So essentially, it automatically invalidates any inheritance that goes to them. Um, but if you don't have a successor, then your assets may have to go through probate. So that can be a big issue as well. So you really need to make sure that that's updated. Um, Additionally, if you nominated your ex-spouse as a trustee or an executor in your will and trust, um, that appointment would also be treated as if they predeceased you, and the successor would step in. But once again, if you don't have a successor appointed, you've got a big problem, and that's something that needs to be addressed right away. That's all that changes upon a divorce. Every
Mm-hmm.
other part of your retirement plan, disability plan, estate plan stays the same. So you actually have to physically make sure to change that. Um, the agents that you nominate under your power of attorney. If you remember, we discussed in a previous video about a financial power of attorney, and that gives somebody the power to have access to all of your assets and do anything that they want with it if you are mentally incapacitated and cannot do so on your own.
Mm-hmm.
If you nominated your ex-spouse, that means that your ex-spouse or the person you're in the process of divorcing would now again have access to all your finances and can do whatever they want with it. That's a horrible situation to be
Yeah.
in. Even worse is for your advanced healthcare directive. We talked about this in a couple of videos, but if you nominated your ex-spouse as your agent for the advanced healthcare directive and you ended up in a coma, your ex-spouse, who is trying to get half of your assets or more, now has the choice as to whether or not to pull the plug on you and let you die or to keep you alive, and then they can inherit what you have. So that's really a terrible situation to be in, and that's, I think, to me, just as important as is focusing on how the assets are split up. I mean, obviously, figuring out how your custody and visitation of your kids is the most important, but when
Right.
it comes to financial, I think that that's just as important.
And I was going to ask you, Phil, what is there something that people should keep in mind when they first get married, when we're all in the lovey-dovey stage? It's like, what
We're going to
what
get to
would
that.
you
We're
advise?
going to get to that in our next video, actually.
Oh,
Yep,
okay. Thank you.
absolutely.
Yeah.
Um, so then, in addition, let's say you did have a will and a trust, and you had gifted something to your ex spouse's family. That doesn't get invalidated. So, if for let's say for capital gains tax purposes, you willed everything to your ex spouse's parent, that would still happen if you died, and then your ex spouse's parent would get everything, and essentially your ex spouse is getting everything. So, you really want to make sure that you change your estate planning documents or create estate planning and documents when you're going through a divorce. Um, another way that divorce affects it is it could affect your parents' estate. So let's say your parents were giving something to your ex-spouse.
Mhm.
If they don't change their trust and something happens to your parents, those assets would go to your ex-spouse rather than you, and I think you're going to be pretty disgruntled at that point in time. Um, Retirement accounts, other financial accounts, life insurance. You guys see this all the time, I'm sure.
Mhm.
But if you put your ex-spouse as a beneficiary on your financial account and you die, even if you're in the process of divorced or already divorced, they're still the beneficiary. They're the ones getting the policy. So you really need to make sure that that's taken care of as well. Um, the bottom line is that you really need to work with a divorce attorney and an estate planning attorney from the very beginning. Um, you if you hire a divorce attorney and they're a solo practitioner, and I know that there's ones out there that do this, and I really feel bad for their clients, but if any divorce attorney that's a solo practitioner tells you that they can do your estate plan and your divorce, they are incompetent in both areas, because you cannot possibly have enough time in the day to learn everything about divorce law, everything about tax law, everything about asset protection law, everything about estate planning law, and have a practice where you're helping clients. It's just not possible. So anybody that claims to do that is a fraud and not very competent. And so you should really look for one divorce attorney and one estate planning attorney, both that specialize in each of their fields so that you can get the best protection possible.
That makes a lot of sense, Phil. Yeah, there's no such thing as a jack of all trades for law. So I really want to thank you for sharing your perspective and your knowledge, your vast knowledge. And I want to thank all of our viewers for watching, and hopefully this is information that they can share with other people. And your contact information is below, so we're leaving that for our viewers, as well as QX Financial's contact information. I want to encourage all our viewers to like, share, and subscribe, and we look forward to seeing you at the next video.
Thank you very much and have a great afternoon.
Thank you. You do the same.